Welcome to another presentation on this learning aspects of unprofessional conduct. And this time we're going to be discussing hearings. As you may recall, there was a session earlier where we talked about some of the complaint process and how complaints and concerns are brought forward to the Alberta College of Medical Diagnostic and Therapeutic Technologists. So we're going to have a little bit more discussion of what happens when one of those complaints moves forward to a hearing. And again, by way of introduction, my name is Jason Kully, and I am a lawyer, field law in Edmonton, and I provide support to the college on all manner of complaints and issues related to unprofessional conduct and regulation of members of the profession. So today we're going to go over a number of topics, which include an overview of hearings. And before we get into that, we're going to take a little step back and talk about some of that complaint background. Then we're going to talk about what a notice of hearing is and what it might mean as for a member of the profession and as one of the registrants. We're going to talk a little bit about who is at these hearings and what one might expect if they are a participant in a hearing. We're going to look at two different types of hearings, which are contested and uncontested hearings, and what that means. Touch on the duty of fairness a little bit as well. And then we're going to get into a longer discussion about the hearing phases and what it would actually look like to have a hearing related to a complaint of unprofessional conduct and what that would mean for a registrant as the one being subject to the complaint, as well as an individual who may be called as a witness or a participant or an observer of these hearings. And with that in mind, a little bit of an introduction, we're going to start with an overview of hearings. And as I said, we're going to take a little step back from our last presentation that you may recall about how we talked about how the college is the one responsible for the regulation of the profession and for regulating the conduct of the members. And with that in mind, it receives and manages those complaints of unprofessional against the registrants as part of its duties and mandate under the Health Professions Act. So the government has entasked the college with the regulation of the profession, and it is members of the profession that help make up that self-governing profession. And then the college has that authority to enforce the ethical conduct and its standards of practice in relation to those complaints to ensure that the public's health and well-being is protected. So when a complaint comes in, it is up for the college to address it in a manner that it sees fit, which will lead us to this discussion of hearings and where this idea of hearings comes from. As I said, these complaints, these are the things that the college is dealing with. And these complaints can come from members of the public, any member of the public, any person. So it doesn't have to just be somebody who has received treatment or services. Really, any person can lodge a complaint of unprofessional conduct. And you've heard me mention those words unprofessional conduct a few times. And just as a reminder, it can be a variety of things, but the ones that we generally see that it is defined as is it includes that displaying a lack of knowledge of or a lack of skill or judgment in the provision of professional services. So that's a concern in how the actual service is provided, a contravention of the Health Professions Act, a code of ethics, or standards of practice. So a failure to meet one of those minimum requirements, minimum standards, or this harming of the integrity of the regulated profession. So some conduct that calls the reputation of the individual or of the profession as a whole into disrepute. So those are the normal, often the more common ones that we see of concerns being raised. And as I said, any person can raise these. It can be a coworker, it can be an employer, it can be an individual receiving the service, it can be a concerned member of the public. So there are many different ways that these complaints can come forward to the college. When the college receives one of these complaints, it then evaluates the complaint to determine if any of these definitions, any of these concerns are raised, and if that conduct is there, if there's some evidence of that conduct, what response might be appropriate given some of the severity, given some of the underlying circumstances, and really just an assessment of how that conduct should be addressed. And in that regard, the HPA does give the college an authority to deal with complaints in a variety of ways. A complaint can be resolved early on through an agreement between the college and the member. The college can investigate those complaints and get more details, get more information. It can use external investigators to do that, or it can do it itself. It can get experts to look at a matter to determine if there is some concerns that are maybe outside of the knowledge of the college and needs that expertise. It can dismiss complaints. So if a complaint is brought forward that is found to be trivial or vexatious, or there's a lack of concern and lack of proof or any suggestion of unprofessional conduct, that complaint can be dismissed, or it can take other actions under the HPA. So, and one of those other actions is a referral to a hearing, and that's what we're really going to talk about today. But it's important to know that when complaints are brought in, there's a variety of ways they can be addressed. It's not always a hearing that is needed to address a concern of unprofessional conduct, and there are other tools available to the college, but the hearing is one of those most important ones, and that's really what we're going to talk about today. And just that note on the slide there, that certainly college has the authority to investigate and administer complaints, including referring them to a hearing, but the college does not have any authority or ability to compensate complainants or require registrants or their employers to do so. So a complaint or a hearing of unprofessional conduct is really about concerned with addressing the underlying conduct of the registrant and addressing that conduct in a manner that helps to protect the public. It is not about compensation to a complainant or any retribution for the complainant. Said, what we're really going to focus on is the hearing. So here, as you'll see, if the complaints director looks at the complaint, looks at any investigation report that's been conducted, looks for that information, determines that there is sufficient evidence of unprofessional conduct. You'll recall those three definitions we looked at. So if there's sufficient evidence of a lack of skill or judgment in the professional services, or if there's evidence of a breach of a standard or practice or a code of ethics, then the complaints director can refer that complaint to the hearings director, who will schedule a disciplinary hearing with the hearing tribunal. And these are the things that we're really going to talk about here today, is looking at that hearing, which is a legal and formal process that is used to address complaints and that is conducted by the hearing tribunal. And that date by the hearings director has to be set within 90 days of receiving that referral. So there's certainly some timeliness needed. It's important to note that doesn't mean a hearing has to be held within 90 days, but there has to be some date. It can be a date in the future. It just has to be set within those initial 90 days. When we look at hearings, again, talking a little bit about the background. Now, where we're at post-COVID, we've seen that hearings are capable to be held online, and hearings are generally held virtually. So there is a possibility for them to be held in person, given certain specific circumstances, but the general rule and the general stance is that the hearings will be conducted virtually using electronic means, and that still allows everyone to participate and to participate fairly. So they'll be held virtually. They are open to the public. So that means that any member of the public, any employer, any individual can attend those hearings unless someone seeks an application to close the hearing. And that application can relate to certain parts of a hearing. It can relate to the hearing as a whole, but it's just a way to allow the hearing tribunal to determine that there are certain parts of a hearing, or maybe a hearing as a whole, that is inappropriate to have members of the public observe. And you'll see there on the slide that there's a variety of different things that need to be considered by a hearing tribunal, and any one of those can be reason to hold parts of a hearing in private. So there could be probable prejudice to a civil action or a prosecution of an offense. So if there's going to be information that might have a negative impact on some other proceeding, that can be held in private. If there's a need to protect the safety of the person or the public, so if they're a vulnerable individual and they'd be exposed to safety concerns, if there's confidential information, which could be financial, it could be personal, it could be health, a variety of different things where revealing that information to other members of the public would be prejudicial and would outweigh the desirability of an open hearing. Other things to consider are where the presence of a member of the public or someone else could compromise someone's ability to testify freely. So if there's concerns that if someone is observing, then someone may not say things that are actually true, or they may feel vulnerable or unsafe. So that would be a consideration. And the last one, where there's just any other reason that a hearing tribunal or the legislation may say that it is needed. So we have a default rule that says hearings are open to the public and anyone can come see. But there are situations where a hearing tribunal may determine that it is more beneficial to have parts or the whole hearing held in private for these considerations. And if the hearing tribunal makes that determination, they do have to provide reasons as to why. They can't just say this is a closed hearing. It will have to provide some information to indicate why the hearing needs to be held in private and why one of these may be relevant. So that's really the background. You get these complaints. They're assessed by the complaints director. There can be a variety of different ways to address the complaint. And if a hearing is needed, they'll be sent to a virtual hearing that is open to the public in these cases. And when we look at what is being addressed at the hearing, in that regard, the hearing process begins when the college provides a notice of hearing to the hearing tribunal. That notice of hearing is really a list of the matters and concerns and the allegations that are being sent to the hearing tribunal. So this will be a notice to the member and to other individuals and to the registrant that says, here are the concerns that the college has with your conduct, and here are the things that we are asking the tribunal to address. So it will have that factual information of it is alleged the registrant engaged in conduct X on a certain date, and here are some specifics that are of concern. And it will contain some information that says, and this is alleged to be unprofessional conduct because it breaches the standards of practice, or it brings the integrity of the profession into disrepute, or other concerns. So it is really a way for the registrant to know the case against them and have an opportunity to understand what is being alleged and for them to respond to those concerns. And it is the information for the hearing tribunal to set out what the hearing tribunal is being tasked with reviewing and deciding. Because the hearing tribunal's task is to review those allegations and to determine if they are proven. So they need to know what the allegations are that they are addressing, and the registrant needs to know what the allegations against them are. See there, a registrant is entitled to attend a hearing, that public hearing where these notice of hearing and allegations are being decided. A registrant is entitled to attend the hearing with legal counsel. The college does not provide legal counsel to the registrant, but the registrant may obtain one through insurance, through other means, and that legal counsel is able to attend. In the event that a registrant chooses to not attend the hearing tribunal will proceed or can proceed, depending on the circumstances, if it is established that they're confident the member is aware and has chosen not to attend, the hearing tribunal can proceed in their absence. Is not a case where an individual is automatically found to have engaged in the conduct. The college still has to prove those allegations. And if there is a finding of those allegations, then sanctions can be imposed, even when the individual is not present. So we have this notice of hearing. It sets out a date, it sets out a time, it sets out the allegations. The registrant will receive that. They can go get a lawyer to help them, and then they will generally attend that hearing on that date and time to address those allegations. We'll get into this in a little bit more detail, but just very generally, the hearing tribunal will hear the evidence presented by the registrant, the complaints director, and all the witnesses that attend. And the hearing tribunal then determines if those allegations are proven and if unprofessional conduct has been established, and if so, what sanctions should be imposed. And really, this discussion here today, this presentation, is going to focus on these 2 points: how the hearing tribunal proceeds to hear evidence, how they proceed to decide, and how it will proceed to make a determination. So we're going to come back to lots of this, but these are just really important things to consider. And you have heard me mention the hearing tribunal a few times already. We're going to keep talking about it in order to understand who the hearing tribunal is and what the hearing tribunal is. it is important to know that the hearing tribunal is members of the profession and members of the public who have been elected and selected to determine these complaints of unprofessional conduct. So they are the fact finder. They are the ones that hear the evidence and come to the conclusion. So in that way, they're like a jury, they're like a judge. They are the ones that are hearing all the information and making a determination as to what happened. So that hearing tribunal consists of those elected individuals from members of the profession and members of the public who are on this tribunal and who are making these determinations. It's important to note the hearing tribunal is independent from the college. The hearing tribunal they're not employees of the college. They don't have that relationship with the college. They do exist under the Health Professions Act, and they have certain statutory obligations and requirements. And they are the one that are functioning like a court to hold these hearings and make decisions. But it's important to note that unlike a judge, unlike someone in court who may not have certain familiarity with the specifics of the profession, these are members of the profession who have special expertise and understanding about the areas of practice, and they will have an understanding about those types of concerns, about conduct and competence within the practice of the profession. So it's really it's that regulation, that being determination by members of the profession and peers of the registrant who is going through that process. So in that way, there is a good understanding and that self-regulation that these members of the profession who are serving, who have that experience, and then members of the public who are there to protect the public interest. So we have this panel, usually 4 members, it can be more. They are the ones that are acting as the court and as the decision maker to make that determination. Beyond the hearing tribunal, there will be other people at any of these hearings. So we have hearing tribunal members. So as I said, it's usually going to be 4, could be more. They may have their own independent legal counsel. So that legal counsel is not an advocate for the complaints director or the college or the registrant. That individual is a lawyer who assists the panel, the tribunal, in understanding their role and carrying out their tasks. So that is somebody who is not an advocate for either of the parties and is there to help the tribunal. There will be the complaints director, who I've mentioned a few times. That is a position under the Health Professions Act. They are specifically the one that are there to engage in these issues. In some ways, they can be seen as a bit of a prosecutor role. They're the ones there that are presenting the evidence, presenting the information for the hearing tribunal to make a decision. That individual, the complaints director, will often have legal counsel. So they will have a lawyer who will act on their behalf, who will present that information to the tribunal. The investigated person, the registrant, will be at the hearing. As I said, the registrant can choose to have legal counsel. Again, they don't need to have legal counsel and can represent themselves, but there's certainly a right to have a lawyer present if one is chosen. So that lawyer will also be there. There will also be a court reporter who will be there to make a transcript of the hearing. So that can be used for appeals or it can be used in other cases. So we'll have that transcript there to document the proceedings. A complainant can attend. As you'll recall, I said that the hearings will be open to the public. So a complainant can attend. They may be there as a witness. They may be there to view. Other members of the public may be there to watch. There may be other witnesses. So those will all be able to attend, but they are not a party to the hearing. The only parties to the hearing are the registrant and the complaints director. And then the hearing tribunal is the one tasked with making a decision. And anyone else is there as an observer or just as a witness. So they're in a different role. And as I said, you'll see on the screen there's also witnesses who can attend. And those are the people who are being called to present that information. They may have seen something, they may have observed something, they may have written something that is relevant, and they need to be there to present that information to the hearing tribunal so they can make their determination. When we look at the hearing types from a big picture, as we said, the registrant will get their notice of hearing that sets out the allegations. Then we have these 2 types of hearing. We have what's called an uncontested hearing or a contested hearing. So in an uncontested hearing, after the registrant gets that notice of hearing, they may say, yes, this is being alleged, I did engage in that conduct. So I did on that date fail to document in this way, and I am prepared to admit that. So that is a choice the registrant can say. Again, it's always up to the complaints director to prove the allegations. There's no presumption of guilt. It's always that presumption of innocence and up to the complaints director to establish. But a registrant may say, I am prepared to admit this conduct. So if they do admit those facts and allegations, the matter proceeds by what we call an uncontested hearing. And what happens is the registrant and the complaints director will put together what we call an agreed statement of facts or admissions. And in that, that is a written document that has certain facts that are agreed to. So instead of needing to call witnesses to prove something, because again, there's no information for the tribunal, the way they get their information is through witnesses who will say, I saw this person's charting on this date, and this is what it had, and then those charts will be presented. That's one way to prove something. Or the parties can just agree that on this date, the member did not document properly. And here's why. So those agreed facts become the evidence before the tribunal, and then the tribunal can use those factual statements to make the determination on the allegations. So there's no need for witness testimony. There's no need to have the full process. There's still a hearing, and we'll talk about that more, but it's a much simpler hearing because the individual is acknowledging what has occurred and is admitting to the facts. So as I said, even though this may proceed in this fashion, the hearing tribunal still needs to make a conclusion. They still need to accept that admission, and they still need to provide a written decision saying that, yes, this was admitted, and here are our findings, and if these conduct is actually proven. So they still have to go through that process. The other type of hearing is a contested hearing, where the registrant is not admitting the allegations, they're denying it, or they're not admitting it. And as I said, the complaints director, the college, has that responsibility to prove the allegations. They must prove that the facts occurred on a balance of probabilities. They do that by establishing the facts through calling witnesses and presenting documents. So they need to be able to show that that issues as alleged occurred, and they do that through having people discuss and talk about what they saw or what they've done, and having that information presented to the tribunal for their consideration. The registrant has the ability to testify on their own behalf as well. They can call other witnesses to present information. They can testify on their own behalf. And the registrant will also have the ability to test the complaint director's case by cross-examining its witnesses and making arguments as to why that evidence doesn't prove what the college is alleging, or why it shouldn't be believed, or why there are other concerns. So the registrant has a full opportunity, as you'll see on TV or in these other proceedings, where they have the opportunity to contest and challenge the case against them and to seek to demonstrate that the conduct did not occur as alleged or as explained by witnesses. The hearing tribunal then decides who has demonstrated the facts, who has proven things. Has the complaints director proven this on a balance of probabilities, or has the registrant been able to demonstrate that there is a lack of proof on a balance of probabilities? If they decide that the complaints director and the college did not prove the case, that's the end of the matter because there is no unprofessional conduct. But if the hearing tribunal decides that the allegations are proven, then it has to go on to determine sanction. And we'll talk about that here today too. So, but before we get into all of that, talk a little bit about the duty of fairness, because this is important. It is understood that when registrants are facing allegations of unprofessional conduct, it is a serious issue, although they're not going to court. It's not in front of a judge. It's not a criminal offense. These are still very serious issues, very serious allegations that can have significant outcomes and consequences for the registrant and their career. So in that regard, it is recognized that there needs to be procedural fairness in the process, in the hearing process, to ensure that the registrant is treated fairly and appropriately. That means that there is a collection of protections and rights that are afforded to the registrant in this hearing process and in this administrative decision-making process. So there are rights and interests of the registrant that are at stake, and there will be a duty of fairness. And what that looks like in a hearing process is relatively high and includes things like the right to receive notice of the allegations. So, as I said, in that notice of hearing, there will be specific information as to what is being. The registrant cannot be found to have engaged in unprofessional conduct that is not found in that notice of hearing. This is a recognition that it is unfair to try to ambush somebody or to try to have the registrant's entire career being adjudicated. It is only those issues in the notice of hearing, which the registrant has been informed of, which need to be addressed. Beyond that, the registrant will have the right to receive disclosure, will receive evidence of the information. They'll know what information is being presented against them. They'll know what witnesses are being called, and they'll have those opportunities. There's also this right to a hearing. So we're talking about the hearing process. And the reason we're talking about that is because procedural fairness requires there to be these kinds of hearings when these significant issues are at stake. We talked about presenting evidence and making submissions and cross-examining. Those are all part of the procedural fairness requirements. So you might be asking, well, why do we have to go through such a formal and rigorous process during when we're addressing allegations of unprofessional conduct? It's because those are rights for the registrant, so they can defend themselves and they can have this high level of procedural fairness when addressing the allegations and complaints against them. So, with all of that background in mind, we're going to turn to the hearing phases and what a hearing might actually look like. So, there's going to be some similarity between the hearing phases in a contested and uncontested hearing, those two things we talked about. Remember, contested is when the registrant is not admitting the allegations, and an uncontested is when they do. But even in both, there still remains these two phases of a hearing. Those we have a merits phase. So that merits phase comes first. That is where the hearing tribunal is deciding whether those allegations of unprofessional conduct are proven on a balance of probabilities, or we're looking at those issues themselves. And that's where there may be an admission, there may be evidence. That's looking at, did unprofessional conduct. If no unprofessional conduct happened, then the hearing just ends. We don't get to the second stage. But if there is a finding of unprofessional conduct, then the tribunal goes on to consider an appropriate sanction. There may be something called a joint submission on sanctions. So, in the process of an uncontested hearing where the member is admitting the allegations, they may also reach an agreement with the complaints director as to what sanctions are appropriate. So, in exchange for admitting to the conduct, they are reaching an agreement on what sanction should be imposed. If the tribunal is presented with this joint submission on sanction, the tribunal is not bound by that joint submission. They must still make a determination on an appropriate sanction. So they're not guaranteed those joint submissions. But the law has developed to recognize that the tribunal should only interfere in rare and exceptional circumstances. The courts have recognized that when an individual pleads guilty, when they make an admission of unprofessional conduct in exchange for some joint submission on sanctions, some joint proposal on what sanctions are appropriate, that the registrant should have some certainty that that proposal will be accepted. So that's why we have these uncontested hearings often, where a member may say it is appropriate for me to admit the conduct, as then I have the ability to reach an agreement on a sanction. If a registrant denies the conduct and then they proceed to sanction, they can argue for an appropriate sanction, but then it's up to the tribunal to make that determination without any of this law on when those submissions should be accepted and what a sanction should be. So that joint submission provides some certainty for a registrant. And we have these two distinct stages for important reasons. So the hearing tribunal has no authority to impose sanctions unless it has made a finding of unprofessional conduct. So really, it's important for the tribunal to know we need to make these findings of unprofessional conduct first and then deal with sanctions. We shouldn't allow this concern of sanctions to interfere with our assessment of whether the conduct occurred or if it's unprofessional. So the tribunals will deal with those allegations of unprofessional conduct first, and then turn their mind to whether sanctions are appropriate if there has been findings of unprofessional conduct. And it would be a concern if a hearing tribunal was looking at what sanctions would be prior to making any determination on the conduct. The conduct is the first part, and it's only if the conduct is established, if those allegations are established, that sanctions are relevant. So, what happens at these steps? Here's a way to look at. So, we have in a hearing, this virtual hearing, it's called to order. The members of the tribunal are there. The registrant and their lawyer maybe are there. Again, they don't need a lawyer, but they can have one. The complaints director and the complaints director lawyer are there. They all go through these preliminary matters, talking about witnesses, talking about documents, those kinds of things. Then each party gets to make an opening statement, which we'll talk a little bit about. Then the parties call their evidence, generally through witnesses or through that agreed statement of facts. Then the parties make closing statements, so those closing arguments you might see on TV from Law and Order, kinds of things. Then we go to a merits decision. So that's all of that. You can see in the yellow as part of the merits phase, that first stage. Then, if there's a finding of unprofessional conduct in that merits decision, the parties make submissions on sanction. So they're like those closing statements. They're making submissions on sanction. Then the tribunal can make a sanctions decision. Again, part of that purple, those are the sanctions phase. And then there can be written reasons. So there will always need to be written reasons, but they can arrive at different stages. And in this is a single hearing where those written reasons are all provided at the end. And that's, you can see the other colors. So you can see merits phase, sanction phase, decision. We're going to unpack a little bit about each of these. Look at the merits stage. So what happens in a hearing of unprofessional? A little bit about it, but what actually happens? Here, the hearing tribunal has a chair. There's somebody who is leading the tribunal. They will call the hearing to order. They're going to be on the screen, on a Zoom call. Chairperson's going to say, we're calling the hearing to order. They're going to use what we may call a script to go through some of the processes. They'll introduce the other members of the tribunal. They'll establish whether the complainant and registrant are present with or without representatives. The complainant may be there as a witness, whether the complaints director is there. If someone is there without a lawyer, the hearing tribunal will confirm that they are prepared to proceed without their legal counsel or without a legal counsel, just to ensure that that's present. The chairperson will go on to just assess those preliminary objections. So there may be concerns about members of the tribunal. There may be concerns about timeliness. Those will all be addressed at that preliminary stage. Once those objections are dealt with, or if there are none, the chair will read the notice of hearing allegations aloud just to confirm that the registrant is aware of the conduct that they are facing. Then the registrant will be given the opportunity to admit or deny the allegations, again, whether this is a contested or uncontested hearing. And then the tribunal chair will ask the parties for their opening statements. The college goes first, and then the registrant can decide whether they want to make their opening statement right after, or they have the ability to wait until the college has finished calling their evidence. So they can wait and say, well, I want to see what the college presents first. And then once the college has done their evidence, I'll then make an opening statement about what has happened. Or they can do it right at the beginning before anyone calls evidence. It's a bit of a strategic choice. So that is something for a registrant to decide. These opening statements are made. Then the parties present evidence. So we've talked about this a little bit. Witnesses are called. They swear an oath that they're going to tell the truth. They're asked questions by the complaints director or the registrant or their lawyers. They can be asked, what did you see? What did you do? What was presented? What kind of documents did you create? All of these witnesses testify, and they talk about things that they saw, any statements they made. They talk about what happened. They can be cross-examined, so their evidence can be challenged. This is really what you would expect from any court proceeding that you've seen on TV, that you've seen in person. Just this opportunity for people to tell their story under oath and to have questions asked of them. These documents can be entered. Oftentimes we know documents are important. As I said, there can be allegations of charting. So any chart notes can be entered. There can be other things that can be complaints from patients, written notices from an employer. All of these things can be entered as well. They can be entered through witnesses, or they can be entered by agreement. So we have these witnesses talking, we have these documents being presented. The hearing tribunal is listening to all of this and trying to decide, are these allegations of unprofessional conduct proven? regard, the college, you've heard me talk about this a little bit. College presents its case first because the college has the onus of proof. They are the ones that need to prove that the allegations occurred on a balance of probabilities, that some 51% standard. Is it more likely than not that these allegations and this conduct occurred? And again, the college and the complaints director has to prove that. The member registrant doesn't have to prove anything. It is up to the college to prove. The college presents its witnesses, the registrant can cross-examine them, the college can ask a few redirect questions just to look at that information, and the hearing tribunal can ask those questions for clarification. So again, we're thinking about the hearing. Hearing starts, the tribunal chairperson introduces everyone, has this opening clarification, these objections, it introduces, then the complaints director presents their opening statement, then they start calling these witnesses. So that's how things are going. After college and the complaints directors present their evidence, the registrant then can call their own evidence in response. So the registrant presents their witnesses, they ask them questions. The registrant can testify on their own behalf. They are there to provide their story and what occurred from their perspective. College and the complaints director gets to question and cross-examine the registrant and any witnesses they call, and the hearing tribunal gets to ask those same questions. So again, the complaints director goes first, and then the registrant responds. And everyone presents their case and their witnesses and their information in that way. Once all of the witnesses and all the evidence has been submitted, then those parties make those closing arguments. And that's what we've done. Hearing phase, we look at how these things go. So if the registrant has presented evidence, which is usually the case, the college makes their closing argument first. They get to say, here's all the evidence you heard. Here are the allegations at issue. Here's what you should find. Here, hearing tribunal, you should make these findings based on pieces of evidence, and here's why that is the case. Then the registrant makes their closing arguments. They get to say, these are the allegations that aren't proven. Here's the evidence you should accept. Here's what happened. And then there's a little bit of a rebuttal by the college, but it's quite limited. That's what happens if the registrant presents evidence. There may be rare cases where the registrant is contesting the allegations, but is not calling any evidence. Again, those are rare. But if that does happen, then the registrant gets to present their evidence, their closing argument first, then the college responds, and then there's a brief rebuttal. But that's a pretty rare circumstance. Generally, what would happen is complaints director will present their closing arguments, registrant will respond, and then the complaints director will have a little bit of a rebuttal. Once all that evidence is presented, all those closing submissions are made, the hearing tribunal adjourns to deliberate. So the hearing tribunal doesn't decide in front of everyone. They go into a private meeting, this in-camera meeting, which is confidential. And there they have these open discussions as to what type of evidence they heard, what the allegations were, which witnesses they believed more than others, why they believe those witnesses, what findings they're prepared to make. So they take this opportunity, they meet in private, and they determine which allegations are proven and why they're proven, what evidence proves it, what concerns they have, and they deal with all of those issues. So that's where the tribunal is acting as that judge and jury. They're looking at everything that's been presented to them. They're looking at the closing arguments that were made, who they accept made the right submissions in that regard, who presented the evidence and the conclusions that they are prepared to accept. So they consider all of that evidence and all of those submissions and make this determination in these private meetings as to what their findings are, whether the allegations are proven. The tribunal can then reconvene. If there's only one allegation, they may be able to do this in half a day. They may be able to do it in less time. If the registrant has admitted to the conduct, this can take even less time. Because if the registrant says, I admit everything, then the tribunal goes back and says, we've heard them admit it. Here's some of the evidence that is, underlies their admission. We're prepared to accept that. So if there's an admission, it can be a little faster, but if there's certainly contested allegations, it will take some more time. So the tribunal looks, and if they can reconvene and provide an oral decision saying, we find these allegations proven, let's move to the sanctions phase. Or if it's more in-depth, they can provide a written decision on the merits phase and then move to the sanction phase. So there's a variety of ways to address that. As you heard me mention, if a registrant is found not guilty of unprofessional conduct, if the tribunal says we are not satisfied on a balance of probabilities that this conduct occurred, or even we are satisfied the conduct occurred, but it's not unprofessional conduct, then the hearing ends. There's no discussion of sanction. There's no discussion of what could have been imposed. There's no sanctions related to anything. It's just only when there is a finding of unprofessional conduct that the hearing tribunal has to go on to consider what sanctions to consider. We've had that hearing. We've heard all these witnesses. We've heard the presentation of arguments. Everything come to the tribunal and they've made a decision. What happens if they do make a finding of unprofessional conduct? And that's where we get to the sanctions phase. So if there is a finding of unprofessional conduct, then the tribunal has to go on to the sanctions phase. Sanction stage is similar to the merits phase. There can be witnesses presented. There can be evidence presented. There will be arguments made on what the appropriate sanction is. So there can be some similarities, but all of the issues are only relating to what sanction is appropriate. We've already found unprofessional conduct. The tribunal has found unprofessional conduct. So now the only consideration is what sanction is appropriate to address that conduct. And again, we can have those joint submissions on sanction. Those may be relevant. And the tribunal can invite the parties to make submissions in writing, or it can be done orally. So here, there's certainly an opportunity as part of that procedural fairness that you heard me talk about earlier for the registrant to make their arguments, to present their case as to what sanctions should be imposed. In that regard, the purpose of sanctions in these types of proceedings is to ensure that the public is protected in the future and they are protected at the current time from any other acts of unprofessional conduct. So it's not about retribution. It's not about being punitive. It is about protecting the public. And that has to be balanced with fairness to the member. And here, as you said, like you heard me say, the sanction ability only arises after a finding of unprofessional conduct is made. You might be asking yourself, well, what kind of sanctions are there? Is it possible for a registrant to go to jail? No. These are sanctions related to the conduct, and they are outlined in the Health Professions Act as to what possible sanctions are available. So these include things like a caution or a reprimand. So those are written or oral statements from the tribunal as to what type of conduct, what occurred, and any sort of statement as to why that conduct is inappropriate. There can be conditions imposed that can be practicing under supervision. It could be limitations on practice areas. There's a variety of different conditions that can be imposed. There can be a requirement to take counseling or treatment or education courses. There can be a suspension of a registrant's practice permit for a set period of time, and that can be a short period, a day or a week, or it can be months, it can be years. So there can be the suspension of the practice permit. There can be fines. There can be cancellation, which is the most serious penalty that can be imposed. So the practice permit can be canceled, which would mean that the individual would not be able to practice. And there is this phrase that's called any order the hearing tribunal considers appropriate. So the legislation, the Health Professions Act, recognizes that the tribunal has the power and authority to determine what sanctions are needed. And there is some ability to for the hearing tribunal to come up with creative solutions that are needed to protect the public. And again, that's what it's about at the end of the day. It's how does the tribunal impose sanctions against the registrant that will meet that goal of protecting the public, meeting that underlying purpose. So those are all the sanctions that can be imposed. When we think about, well, how are sanctions imposed? What are some of the limits? So some of the limits on what sanctions a tribunal can impose are that the sanction has to be connected to the unprofessional conduct. So that if someone has engaged in some sort of conduct related to poor documentation, which has been the example I've been using, there can be a course related to documentation, to understanding what needs to be documented. It would be inappropriate to have a course to address a documentation allegation where the course then addresses some sort of sexual abuse boundaries or sexual boundaries, because there's no connection between the proven conduct and the sanction. There has to be some sort of connection between the two. Tribunal also can't retain jurisdiction. They're not there to supervise the member. They're there to impose a sanction and be done. And they cannot delegate their decision-making authority. So the tribunal has to make a determination on the appropriate sanctions. They are the ones that have to do it. They have to make the order done. and they have to make an order on sanctions that actually reflects the proven conduct. Beyond that, there's a number of factors that are considered when determining what the appropriate sanctions are. So there's principles that a hearing tribunal must adhere to when determining a sanction. They don't get to just pick out of the thin air. They're not just arbitrarily determining what sanction is appropriate. They are looking at a variety of different things to come to that conclusion. And what they look at is nature and gravity of the proven allegations. Because remember, unprofessional conduct has been found. Sanctions are only imposed when there has been unprofessional conduct. So the tribunal looks to see, well, how serious was this conduct? Was it a sexual boundary violation, which is on the more serious end of the allegations? Was it a single finding of poor documentation that was more in line of a mistake, which is still serious, but it's on the lower spectrum of seriousness? Was it something in the middle? How serious was the conduct? And we can all know, we know what a more serious conduct is, and we know what less serious is. Again, it's all unprofessional, but there is a spectrum when we look at that. So that is something that the tribunal will consider. And of course, there will be more severe sanctions for the more serious conduct and the more problematic conduct. Tribunal will look at the level of intention. So again, was it a mistake? Was it something that was careless? Was it reckless? Or was it something that was intentional? Those are things that will be considered. Again, intent wouldn't be relevant to whether the allegations are proven, generally not. And you might not intend to document something improperly. Doesn't matter if it's not documented in the way that the standards of practice require. That is still unprofessional conduct if the tribunal makes that decision. That level of intention is relevant more on the sanctions phase. So that can look at, again, whether they had an increased level of intention. Was it reckless? Was it something in that regard? The age and experience of the registrant is relevant. If somebody is a more junior or inexperienced registrant and the proven conduct may be explained by their lack of experience, that can be a mitigating factor. That can show, well, a less serious sanction may be needed to deal with this. But if there is somebody who is a more senior member of the profession who has been engaging in the conduct and should have been for long engaging in the profession for a long period of time and really should know better and needs to know better, then a more serious sanction may be relevant. Presence or absence of previous convictions. If somebody has no previous convictions, then that is certainly something that needs to be considered. It is certainly also an aggravating factor where if a member of the profession, if that registrant has engaged in previous conduct and has been found guilty of unprofessional conduct, but they haven't learned from their mistakes. So at that stage, again, the purpose of sanctions is to protect the public. If these conduct keeps occurring, if unprofessional conduct keeps occurring, that shows that the public isn't being protected and a more severe sanction is needed. It doesn't always have to be appropriate, but certainly those previous sanctions, those previous convictions, generally lend towards a more severe sanction, and that is something that the hearing tribunal will need to consider. There is the number of times the offense occurred. If something only happened once, then likely a less serious sanction is needed. But if it is recurring, if it has happened a number of times, if it is something that is occurring for a long period of time, those are all things that might lend towards a more serious sanction or just a sanction that addresses it in a different way. So if something only occurred once, maybe some remedial learning is enough to address it. But if it keeps occurring and it's intentional, then there may be a more serious sanction in terms of perhaps a suspension or a fine to really protect the public in that way. The age and condition of the patient is relevant because if there is a more vulnerable individual, if there's a more vulnerable patient, then there may be a different sanction that is needed to protect the public. Because again, it comes back to that. So if it's a child, if it's an elderly, if there is something where there should have been a higher level of care, given those particular circumstances, we have to look at how the public can be protected in the future and what sanction would be appropriate. And we have this role of the registrant incurring what happened. So in an uncontested hearing where the registrant has made admissions and they've helped move the process along, they prevented everyone from having to testify, they've addressed it in that way, that is can be seen as a mitigating factor. So that may mean that the public needs to protect the public, a different sanction is needed than whether if the member had contested everything and had denied the issues. Because if someone takes responsibility, if they show a willingness to take accountability, that is relevant in assessing what is needed to protect the public in the future. Few other things to consider: the impact on the patient. So what level of harm occurred, what level of harm could have occurred. Those are things to look at with respect to what sanction is needed to protect the public moving forward. Whether there has been other consequences suffered by the registrant, so have they been terminated from their job, were there other professional consequences imposed? Those are things that need to be taken into account. There can be other mitigating circumstances. So was the registrant suffering from any sort of matters in their personal life? Were they suffering from a disability that may have impacted their ability to provide appropriate care? Those are all things that can be considered. Again, none one factor is determinative, but they all are looked at together. They're all assessed holistically to see what would be appropriate to address the concerns and to protect the public moving forward. And one of the most important ones is this need to promote deterrence, because that is about protecting the public. So the tribunal must consider what level of sanction is needed to deter the specific registrant from engaging in the conduct in the future, because that ensures the public is protected, and what sanction is needed to deter all members of the profession from engaging in that conduct. So if another member of the profession was to read the decision and see, oh, this individual received this sanction, I'm going to ensure I don't engage in that conduct so I don't receive that sanction. That is what we're looking at, is this deterrence, this general for all members of the profession and specific deterrence for the registrant themselves. Is the tribunal looking to ensure that the public is protected by demonstrating that to other members of the profession that this conduct will be treated seriously and will be addressed through appropriate sanctions, and ensuring it doesn't occur in the future? That deterrence, that is a significant consideration for a tribunal, as is the need to maintain confidence in the integrity and the confidence in the profession. So the public confidence in the profession and in the way the profession is regulated and its ability to protect the public, that is essential. So the tribunal will assess whether there is such a sanction that is too severe or too lenient that it would call into question, from the public's perspective, how the profession is regulated. So if somebody engages in very serious conduct and there's a very lenient sanction, that may give rise to concerns from the public that there isn't an effective regulation. So that is what it's looking at. Sanctions have to be appropriate, and they must ensure that the public's confidence in the profession is protected. And the last factor on there is the range of sanctions in similar cases. So you look to see they're not binding, they're not guarantees of what sanction will be imposed, but back to that principle of fairness, it is appropriate to treat cases that are similar in similar ways. So if a registrant engages in the same conduct as somebody else, they shouldn't be treated more harshly or more leniently than that other person. There should be some general guidance as to what may be inappropriate. Again, every case is different, and we look at all of these factors. They may result in a different sanction, so it doesn't have to be the exact same, but a tribunal should look to these other decisions and other conduct as guidance. So that is a lot of information with respect to how a tribunal determines a sanction. They're looking at all these different factors, they're looking at all the specific circumstances, and they're looking to see, how do we address the conduct of this registrant to ensure that the public is protected in the future? And those are all of the issues related to sanctions. The other thing that is important that happens in this phase is costs. So the hearing tribunal can order the registrant to pay all or part of the costs of the investigation and the hearing. So this is a recognition, it's in the statute. It has been recognized from the legislature that the college is engaging in these services. They are protecting the public, and this comes at a cost. There's things like a lawyer, there's investigators and investigation costs that need to be paid. If the hearing occurs in person, there may be hotel costs or rent room costs. There may be costs for tribunal members. There's a variety of costs that can arise in these circumstances. And the legislature has recognized that if the college is going to bear all these costs, it may mean that other members of the profession, other registrants, have to pay increased membership fees, or they may have to look at the costs. So the legislature has said the tribunal can order the individual who engaged in the conduct and who was found to have engaged in unprofessional conduct. Again, this only comes up if there is a proof of unprofessional conduct. Legislature has said, well, tribunal can order that person to pay costs to the college to account for some of these fees that have been incurred, only to show that the individual engaged in unprofessional conduct. The hearing and all the costs wouldn't have been necessary, but for the conduct of the registrant, so they can be required to pay a portion or all of the costs, and they can be required to pay that in a set period of time. So that's something to keep in mind. And one important thing to note is the legislature has not provided any means for the tribunal to pay the costs that a registrant incurs. So if a registrant has a lawyer representing them and they incur costs or fees related to the lawyer, the tribunal does not have the ability to order costs against the college in favor of the registrant if the registrant is successful in showing there was no unprofessional conduct or in any circumstance. It is only an ability for the tribunal to allow the registrant to pay the college, not the other way around. And that was a choice made by the legislature. In looking at costs, so they're not punitive, they're not a punishment, they're not like fines. Fines in the sanction phase, those can be a punishment. Those that can be used to deter somebody from engaging in conduct. Costs aren't punitive. Discussed, they're there to fully or partially indemnify the college for its costs and expenses. Those costs and expenses that are only necessary because of the unprofessional conduct of the registrant. There's no presumption that costs need to be ordered. It's up to the hearing tribunal to look at all of the circumstances and to make a determination as to whether costs should be awarded. And the tribunal must decide if those costs are going to be awarded, how much costs should be awarded. And that final amount has to be a reasonable amount. It can't be overwhelming. It can't be a crippling blow to the registrant. And the tribunal has to justify its cost award. It has to show, here's how we came to this conclusion, and here's why costs are appropriate and why this amount is appropriate. Another list of factors. So again, it's not just willy-nilly. It's not just a tribunal deciding on its own accord. They need to look at a variety of factors when assessing costs. They look to see, were all of the allegations proven? Did the registrant disprove some of the allegations? Should they have to cover the cost of the college for things that the college didn't prove? Generally not. They look at the conduct of the parties. Was it an efficient hearing? Was it inefficient? Did parties take actions that extended the hearing or resulted in more costs? That can be relevant in apportioning the costs and deciding how much should be paid. They look at the need for witnesses. This is related to the conduct. Was the hearing more expensive? Were those witnesses not needed? How did that occur? They look at the registrant, again, part of that, if there was an agreed statement of facts. Could the result be reasonably anticipated? Was this something that the tribunal says, well, the costs were only incurred and the member should have been aware that they weren't going to be able to disprove? Were the costs unnecessary? Did they cooperate and allow some of that to be money saved? Those kinds of things. They look at the financial circumstances of the registrant, other impacts on the registrant, how much cost would be appropriate, and just the overall reasonableness of the amount. So there's a variety of different things that they're looking at. Really, tribunals looking to see is, were the costs incurred by the college necessary and were they reasonable? And how much of those costs should be the responsibility of the registrant based on their conduct and based on all of the circumstances. And the tribunal needs to demonstrate and set out in their reasons why those costs are appropriate. Brings us to one of the last comments we're going to talk about is the hearing's now been done. Findings of unprofessional conduct have been made. Findings on sanction have been made by the tribunal. They now have to write a decision. So they have to provide a written decision with reasons. So the decision is unprofessional conduct proven or not? What sanction is appropriate? That's the decision. And then they have to provide reasons. They have to explain what evidence did they rely upon? Why did they come to those conclusions? What were they convinced by? What were they not convinced by? They have to set out all of those reasons on all of the allegations and sanctions, and that has to be done in writing. That is given to the hearings director, and then the hearings director provides that to the parties for their review. these decisions come out in a reasonable time, and they have all of the findings and reasons of the hearing tribunal. In addition, other information that is necessary. So the registrar has to release certain information about a registrant in certain cases. So if a registrant's practice permit is canceled or suspended or has conditions put on it, then that information has to be included on the registrant's record in the public register. So on the online register, other accessible information, those three pieces of information need to be there. That is a statutory requirement. Beyond that, the college has the right to publish or distribute other information about any part of the discipline hearing that wasn't held in private to ensure there's transparency and accountability. So the hearing tribunal can post the decision online, it can provide a summary, it can release information to employers, it can provide certain pieces of information that it determines are necessary to protect the public, as long as it's not providing information that was from parts that were held in private. So as long as it's connected to protecting the public, the college has discretion in what information to provide beyond the statutory requirements, the minimum amount of information it has to provide. Finally, an appeal of the hearing tribunal can be appealed by the registrant or the complaints director, and that goes to the college's council. So that appeal has to be done within 30 days, has to be done in writing, and it has to be provided to the college within that period of time. And then it goes to another tribunal, another body within the college, which is made up of members of council. Important to note, the complainant, because they are not a party to the hearing, they're only called as a witness or somebody who has some information. The complainant does not have the right to appeal a decision. The only individuals that can appeal a decision are the registrant themselves, the one who is subject to the allegations, or the complaints director, as they are responsible for protecting the public. So you can see lots of information that happens, lots of processes that occur, but what we're talking about is when a complaint comes in, it's up to the college to look at the information, to provide this notice of hearing to the registrant as part of that duty of fairness to set out, here's the allegations. And then as part of that duty of fairness, the registrant has this opportunity to defend themselves through these hearings that we've walked through and to argue what findings should be made, whether unprofessional conduct has occurred or not, and to address these sanctions. And there's a variety of factors that the tribunal needs to go through when they're looking at whether the allegations are proven, what information they're relying upon, what sanctions should be imposed, what costs should be imposed. And then they have a duty to provide reasons to everyone in the registrant as well as to why those findings were made. So it's not a court process, but it is still a formal process that acknowledges the seriousness of the issues at stake and acknowledges that the registrant also has these rights. So it is certainly a fair process, but it is certainly a process that has a lot of moving steps. And I'm hopeful that this presentation provided some guidance on some direction on what might occur when there's a complaint of unprofessional conduct, or answer some of your questions just in general about how these hearings take place and what information is relevant and what the possible outcomes can be. So with that in mind, I just want to say thank you for taking the opportunity to listen to this presentation, and I hope it addresses some of the questions that you may have had with respect to a hearing of unprofessional conduct under the Health Professions Act with respect to the college. So thank you very much.